Hey there, I'm estate planning attorney Paul Rabelais, and in this video we're going to answer the often not discussed question of, do I really need an estate planning lawyer to get my estate planning legal affairs in order? Well, the answer of course is it depends, and we're going to dig deep as we address this question. So let's look at an example. George is single, 68 years old, and he has two adult children. Nan, who's 43, and Mia, who's 40, who, according to George, are more responsible with money than George is. George wants, when George dies, for his estate to be divided equally between Nan and Mia, and George would like to set up his estate so that Nan and Mia don't have to go through the court and attorney-involved probate when George dies. He'd like Nan and Mia to inherit all of George's assets without a bunch of legal hassle, delay, and expense. George's estate consists of what I consider to be 9 different types of assets: a home, an ownership or membership interest in a limited liability company, a traditional IRA, a Roth IRA, a brokerage account, 2 bank accounts, an annuity, a life insurance policy, and a vehicle. And if you add up the value of all of George's assets, including the death benefit of the life insurance policy George has an estate that is worth $2.5 million. George knows at 68 he's overdue for putting his estate legal affairs in order, and he contacts an estate planning attorney who's pushing pretty hard for George to hire the lawyer to create George's revocable living trust. But George knows just enough to be dangerous. And George is one of those, I'd prefer to do it myself to eliminate the lawyer expense kind of guys. So as George examines and researches his options, the first thing he says to himself is, wait a second, of these 9 different types of assets that I own, I know that I've already designated my 2 adult daughters as the equal beneficiaries on 5 of those assets. George recalls that he named his 2 daughters as the beneficiaries of his traditional IRA, his Roth IRA, his annuity, his life insurance policy, and his brokerage account. So George says, if I want Nan and Mia to inherit my entire estate with all the probate difficulties, can I designate Nan and Mia as beneficiaries on my other assets? Or in order for Nan and Mia to inherit my home, business, bank accounts, and car outside of probate, do I need to create a revocable living trust and transfer those assets to my trust now? So regarding the home, George realizes that he lives in one of the approximately 27 states that permits people to create and sign a transfer on death deed or TOD deed. So George asks, can I just sign a TOD deed and then my daughters will inherit my house immediately when I die outside of probate? And the answer is yes. And regarding his business, George realizes he lives in a state that allows people to transfer their LLC membership interest via a TOD. So George asks, can't I make Nan and Mia the TOD beneficiaries of my LLC? And the answer is yes. And regarding his bank accounts, George goes to his bank and finds out he can sign a POD, Payable on Death, designation where he can designate that Nan and Mia can receive his bank accounts immediately, easily, and outside of probate when George dies. So he does that. And then regarding his vehicle, George realizes that he lives in one of the 19 or so states that allows its residents to sign a TOD beneficiary for the vehicles that he owns. So he does that and names Nan and Mia as the TOD beneficiaries. So after looking into all of this and filling out all of the paperwork so that all 9 classes of assets have either designated beneficiaries, TOD beneficiaries, or POD beneficiaries, he tells the lawyer, well, what do I need you for? And the lawyer replies, but you may become incapacitated at some point during the rest of your lifetime, and you need to have a lawyer prepare, and you must sign a durable power of attorney and an advance healthcare directive in order for the people that you trust to be able to take care of your money and your medical decisions if you can't do those things for yourself. And George replies, well, my state has a readily available statutory durable power of attorney and advanced healthcare directive that I can easily find online that I can print off and sign. Is George right about that? Well, yeah, he is. So George thinks, Jeez. I have my 9 different assets all set up to go immediately to my 2 adult and responsible daughters when I die outside of probate. I've got access to my state's statutory power of attorney and healthcare directive. But maybe I need an estate lawyer to help me avoid all those estate taxes. I hear those can be as high as 40% of the value of my estate when I die. So does George need to hire a lawyer to help him avoid estate tax? Well, no. You see, for the years 2024 and 2025, the estate tax exemption is scheduled to be in excess of $13 million. George has a total estate of $2.5 million, far less than the exemption amount, even for 2026 when the estate tax exclusion amount is expected to be scaled back to something more than $7 million, depending on how the inflation adjustment kicks in. So now George feels pretty good about himself and his estate. He's confident that based on his estate value of $2.5 million and the exemption amount of $13 million plus, there won't be a nickel of federal estate tax due when he dies. And because he printed off and signed his state's pre-made statutory durable power of attorney and healthcare directive, he's confident that his daughters will be able to act for him in the future if he ever can't sign things for himself. And with the designations that he made on his 9 different assets, he's confident that his 2 daughters will inherit all of his assets quickly and easily outside of probate when he dies. And he's confident that all of this will be done without his needing to hire an estate attorney to prepare his revocable living trust and help him transfer all of his assets to his revocable living trust. So, will this plan work for George where he has no last will and testament, no living trust, he signs his state's statutory durable power of attorney and advanced healthcare directive forms, and he just leaves everything in his name? Will this work out okay for George and his 2 children? Well, it just might. You see, in George's case, with so many states enacting POD and TOD legislation, which allows its citizens to transfer just about anything through a designation form, and with so many state legislatures creating these standard statutory power of attorney and healthcare forms, it seems that state legislatures in some cases are reducing the need, or in some cases eliminating the need, for people to hire an estate planning attorney to avoid probate and avoid the guardianship proceeding. But hold on, let's not immediately unemploy the 200,000 or so estate planning attorneys working in the United States today. Now, just because George's estate was relatively simple, he was single, he had 2 adult responsible children, he lived in a state that had favorable POD and TOD designations laws on its books, his estate was well under the estate tax exclusion amount, and he wanted everything he owned to be split 50-50 between his 2 responsible adult kids. You see, not every family and not every estate in America is like George's. So let's look at some common estate situations where it typically does behoove an individual or a couple to hire an estate planning lawyer to make sure things will be easy for your survivors and things will go exactly as you expect and hope. So the first situation where you'll likely benefit from engaging an estate planning attorney is you're married. While it's possible on many assets to simply name your spouse as your beneficiary on your IRA or other assets, there are a number of important decisions that you need to make if you're married that can impact your family for decades to come. Issues like, do you leave your assets outright to your spouse, or do you leave your assets in a trust for your spouse in order to provide your children with an extra layer of protection to ensure your children will inherit after both you and your spouse pass away? This is an even more significant issue if you and your spouse have 1 or more children from a prior marriage or relationship. A second issue that requires the hiring of an attorney is when you don't want to leave an inheritance in a lump sum to 1 or more of your heirs, whether those heirs are your spouse, your children, your grandchildren, or others. Since children are the most common types of heirs, it's worth mentioning that many parents really like this concept of leaving their children's inheritance in a trust for several reasons. First, parents often want to make their children's inheritance divorce-proof, so that if the child inherits assets in a trust and subsequently divorces, the child will keep their trust, and the child and their spouse will split other assets that they accumulated during the marriage. Another reason parents often feel forced to leave assets to children in a trust is because of the children's lack of financial maturity. Perhaps the child is a minor, or perhaps the child is an adult, but throwing money into their lap all at once is just not what's in the adult child's best interest. So the parent needs to set up a trust to dictate the terms and the schedule at which the child will be entitled to distributions of the inheritance. And then some parents are concerned about children who either have too much debt for comfort or the child has creditors breathing down the child's neck. This isn't an extremely common situation, but dumping money into the hands of a child or heir who has creditors is not protecting that inheritance when the alternative is to leave that child's inheritance in a particular type of trust that is protected from the child's creditors. And yet another reason to engage an estate planning attorney to create your will or trust is that you may be taking some chances by relying on TOD or POD designations. You see, I've reviewed many a TOD or POD designation form over the years, and many of them say that if one or more of the TOD or POD beneficiaries dies before the account owner or asset owner, then upon the death of the account owner, the asset will be transferred to the surviving TOD or POD beneficiaries. This is not what most grandparents want. Most grandparents say something like, if my child dies before me, then I want the deceased child's share to go to the deceased child's children. But many TOD and POD designations do not permit this. Most attorney-prepared wills and trusts provide, if this is what the client wants, that the estate will be passed along to the descendants per stirpes, which means if a child predeceases the parent, then when the parent dies, the predeceased child's share will go to the predeceased child's children. And yet another reason why it may be better to have your assets in your living trust when you die as opposed to relying on TOD and POD designation is to provide that all those estate settlement expenses, whether those expenses are the preparation of your final income tax return and paying income tax, the paying of any debts or credit card bills the deceased person had, funeral expenses, and any other expenses related to the settlement of an estate, it's easier to take care of all of those expenses if they're handled by a single trustee of the deceased person's living trust, and all those expenses are paid off the top before the remaining assets are dispersed to multiple beneficiaries. But if, for example, you have 25% TOD and POD beneficiaries on your financial accounts, and there are estate settlement expenses that must be addressed when you die, then all 4 of the TOD and POD beneficiaries will have to give some of their inheritance back in order to get these expenses paid. And that could be stressful and difficult if one or more of the beneficiaries refuses to or just simply won't give their inheritance back in order to pay the deceased's expenses. And then finally, even someone like Unmarried George in my previous example who wanted to avoid probate by using beneficiary designations POD or TOD on everything he owned, even George would need to create his living trust and transfer assets to it during his lifetime in order to avoid probate if he lives in a state that doesn't permit TOD transfers for LLC or small business interests, real estate interests like the home, or even vehicles. So while there's no doubt that the trend is for state legislatures to enact legislation like TOD designations in order to enable people to arrange their different types of assets in a way to avoid probate, even without hiring a lawyer to create a living trust, many people's estates and family situations are such that retaining the services of an estate planning attorney is just what's necessary to accomplish those unique goals of that unique family. So finally, I feel like this is one of those videos that you could pass along to your friends, colleagues, and relatives who could benefit from clarification around these murky TOD, living trust, and avoid probate murky waters. So feel free to forward this video to someone you think may benefit from it. Have a good day.